27.
Your Lordship said
Not
2000.
2000.
NIT was issued in 2001.
No,
When NIT was issued?
2021.
21.
There's no delay on my part.
No. So it's a 6 years old NIT.
Yes,
Yes.
it was challenged in a writ petition. Man.
There's always a clause that the department reserves a right to cancel.
But the department doesn't say that, Manoj. I can understand if the department says
Ahmadi, the contract period is from 2021 to 27.
no, Manoj. It says that your lease will run from the time that the lease is executed. So the 7-year lease will only, it's not been executed.
Well, it has not been executed, so time has not started running. That
Your
is
Lordship.
But the court has kept in mind the revenue interest of the government.
Yes.
Discretion has not been exercised in your favor. DBA has upheld the order. Why should we interfere in a discretionary order?
So let me answer that. Two aspects. One is, my lords, there is nothing to show that there is revenue loss. I can understand, my lords.
Being on record means
My lords, with
2021,
respect-
whatever would be the rate.
No, with respect.
And if it is advertised now, 2026.
No, my lords. Someone has to come to the conclusion that the price of sand has gone up. There is nothing to show that. Point number one. Point number two is, my lords, the department has never said that please retender. That there is a revenue loss and there is a retender.
Invoke the discretionary
Now the third point.
jurisdiction.
The third point, my lords.
Department may not say so,
No,
because we
third,
know how departments function, but it is after all the High Court, which is the guardian of the Constitution. If it has taken a view that interest of the state would be best served if there is a retender, you require very strong reasons to dislodge this.
So may I now, my lord, state one reason why your lordship should dislodge the reason. Your lordships have repeatedly said that judicial review, my lords, in a tender matter is extremely limited. Only on the principle of Wednesbury arbitrary. The finding of the single judge or the finding of the division bench, there is no finding returned that there is Wednesbury arbitrariness. Your lordships have gone to the extent of saying in a tender matter we will only interfere where the arbitrariness, my lords, borders on perversity. I ask myself this question from the division bench order or from the order of the single judge, where is the finding returned that there is any arbitrariness? The High Court...
In tender matters,
Yes, my lord.
courts have to decide the lease, keeping in mind public interest. Even if you make out a solid point on law, the court may refuse to do so.
It may.
Right?
It may, my lord. Now let me point out.
Maritime, these decisions are there from 2001 on.
Yes. Now let me point out, my lord.
Court may not have referred to those decisions,
Yes.
but the essence of the judgment is this, that this would not be in furtherance of public interest to allow this 2021 tender to proceed.
My lords, may I?
That is the point.
Yes. Now may I answer that? I can understand, my lords, as I said so at the outset. I can understand, my lords, if the court came to the conclusion that there was a substantial price escalation. There is no data before the court to come to this particular conclusion either. Now, otherwise, my lords, the principle is fairly hazardous, my lords, so far as the citizen is concerned. Your lordships have, my lords, starting from Antule's case, said that act of court should do no wrong. That is, my lords, no party should suffer on account of the fact that the list remains pending before the court. There is no portion of the blame which is apportioned to me for the delay, my lords, in this particular aspect. In which case, my lords, I, who is the highest bidder, who has bid substantially over the reserve price, is put to prejudice for no fault of my own. I can understand, my lords, if the court had said that there is a 40% price escalation, there is a 50% price escalation, or there is a 10% price escalation. There is no such finding which is returned. And please see the judgment of the division bench, my lords. The division bench effectively exercising jurisdiction under LPA, that's, my lords, effectively the first appeal against the single judge. There's nothing dealt with by the division bench. It's only, my lords, just one particular line which says that if the single judge has done this, we don't interfere, almost as if it's a 136 discretion. At least in an LPA, something should have been dealt with by the learned division bench. That's my respectful submission.
Otherwise, to the decisions of this court in so-and-so versus so-and-so and so-and-so versus so-and-so, we see no reason to interfere.
Your lordship's discretion, my lords, I can't forget about that.
That is why we are referring to Cochin International and Air India.
Lordship.
These
In
two
fact, your lordships took a view, my lords, in Adani port, which I wanted to rely upon.
Right. So that was there.
That was
not here.
I think I think it will pervade here as well. Lordship, please.